Welcome to EUPrivacyForAll, Session 61 on GDPR, the European Data Protection Board, Article 64 and 65. European Parliament deleted all the provisions set in Articles 64 and 65, putting them in Article 66. On its side, EU Council added some inputs, such as the fact that the EDPB would be a body of the Union and shall have legal personality. It would be represented by its chair. Additionally, it said that the Commission and the European Data Protection Supervisor would have no voting right. The final draft of Article 64 on EDPB sets that the European Data Protection Board will have legal personality and will be established as a body of the Union. It will be represented by its chair, as suggested by EU Council. As currently, it will be composed of the head of one supervisory authority of each member state and of the European Data Protection Supervisor. This is really similar to Working Party 29. Where a member state has more than one supervisory authority, a joint representative will have to be designated, as currently. The Commission will have no voting right, but will have the right to participate in the activities and meetings of the EDPB. The chair of the EDPB will have to communicate to the Commission the activities of the board. Finally, the European Data Protection Supervisor will have voting rights only regarding decisions concerning principles and rules applicable to the Union, institutions, bodies, offices, and agencies. In Article 65, it is specified that the Board will act independently, as Working Party 29 does today, without prejudice to the requests by the Commission on guidelines, recommendations, best practices, or specific advice. The EDPB shall neither seek nor take instructions from anybody. Recital 110 basically stresses all the points already made in Articles 64 and 65. It adds in the end that EDPB will particularly advise the Commission on the level of protection in third countries or international organizations and promote cooperation of the supervisory authorities. Currently, in the directive, Article 29 on the Working Party on the protection of individuals with regard to the processing of personal data leads that the Working Party has advisory status, acts independently, is composed of a representative of the supervisory authority or authorities designated by each member state, and representative of community institutions and bodies, and of a representative of the Commission. It also stresses that where a member state has several authorities in charge, it shall designate a joint representative. What should accountable data controllers and processors get prepared for? First, as for the Working Party 29, know that the EDPB will be composed of the head of one supervisory authority of each member state and of the European Data Protection Supervisor. Also know that, as currently, each member state will have a voting right, the Commission will not have any voting right, and the EDPB will have to act independently. Contrary to what is currently going on with Working Party 29, EDPB will be a body of the Union. It will have legal personality, and the European Data Protection Supervisor will have voting rights specifically determined, that is to say, only one concerning principles and rules applicable to the Union, institutions, bodies, offices, and agencies. The EDPB will replace the Article 29 Working Party when the GDPR comes into force. Finally, the EDPB will advise the Commission particularly on issues such as the level of protection in third countries or international organizations. So the questions triggered now is whether the EDPB legal personality and status of body of the Union will favor a more consistent and practical regulation across EU.